Good afternoon. It's great to be with all of you here on February 20th, and hopeful for those of you that had an opportunity to slow down and appreciate the President's Day holiday yesterday, that it was meaningful. And for those of you who are taking off time this week, perhaps with kids off from school, etc., if you are nonetheless tuning in, thank you all the more for your loyalty. And let me, with the next slide, please, Kathy, walk you through the agenda for today. We have plenty to talk about, notwithstanding that the holiday was just yesterday. Right before the holiday weekend, we saw from Governor Kathy Hochul here in New York State those 30-day amendments, which affect the budget proposal in pretty substantial ways. And so Roger Bearden, who's with us from our Albany office, back on the program, and who is co-deputy chair of the Government and Regulatory Affairs practice, along with me, will be addressing the legislative array of activities. There's plenty there that all of you should be keeping tabs on, and so we thank Roger in advance for that. After that, we're going to have a combined presentation from two different attorneys, Joanna Silver, who is based in our Westchester office, and Taria Jenkins, who is with us from Rochester. And what they'll be covering is essentially what it takes to become a university in New York. There is a lot of activity right now with colleges contemplating whether remaining as a college is the right move for them. Changing and adding graduate programs and the like is of interest, and we've seen among bond clients, many coming to us to learn how to do that. And so Joanna is going to lay some of that groundwork, and then Taria will be talking about the intellectual property implications. As you can imagine, there's a lot that changes if one, as an institution, shifts from a college to a university. Speaking of shift, then we'll switch back to Albany, where Jen Sin is with us. She is a regular on the program and is someone with a large practice involving, among other disciplines, hospitality. She has spoken with us before about liquor licenses and the delays in New York State that we are seeing. There is more information there in terms of what has been shifting and otherwise what has not been. So we'll get the latest. And then Jen will be essentially presenting on a companion topic right thereafter, discussing which are the entities and individuals that would need to be disclosed in an application for a liquor license. There's some change there too that for those in this space, you'll certainly want to know more about it. But for now, I wish to turn it back over to Roger, who is with us to walk through the legislative activities here in New York State. There is a lot to talk about. And so, Roger, thank you so much for taking the time.
Well, thanks, Gabe, and greetings from Planet Albany to all those who are tuning in, whether from Albany or around the state or maybe vacationing elsewhere. A couple of items that wanted to highlight. First of all, from a process standpoint, folks may know that in January, the governor proposes a budget to the legislature, and then over the course of several months, there's a series of negotiations that result in an enacted budget by April 1. And one thing that we did when we first saw the budget that emerged, made sure that we had some information for folks, including, I think, what was of particular interest to those in the human resources space, which was the governor's proposal to eliminate the separate category of COVID leave. And so that's something that remains, and we continue to actively monitor that, and we'll certainly on or about April 1 let you know whether in fact that has become law and then how to move forward with the implementation. As Gabe mentioned, the governor did come forward at the end of last week with so-called 30-day amendments. So the governor has the ability, after having first proposed her budget in mid-January, to propose 30-day amendments Typically, those are simply technical in nature. So, in putting together a several thousand-page document, which is the budget, it is not surprising that there are sometimes errors made, an and that should be an or, a semicolon that ought to be a comma, etc. Somewhat unusually this year, the governor actually made two significant changes to her original proposals. The first, as part of the governor's budget, she had proposed taking $100 million out of what's called the interest on lawyer account, which is the account that is established when folks deposit monies with an attorney. There is interest that is earned in those accounts, and so for at least 30 years and potentially longer, those monies have been dedicated towards the provision of civil legal services for people who couldn't otherwise afford those services. And the governor's proposal proposed taking $100 million out of that account and using it for what would be called general fund relief, treating it as if it were just general revenue. She's rescinded that proposal. And that $100 million will remain in service of the mission of providing people with civil legal services. The second major proposal was a very strong reform to what's called the Consumer Directed Personal Assistance Program. There's a sense in the governor's proposal that the costs of that program, which serves to help people with disabilities, people aging, live and thrive in their homes, that those costs have become out of control, and that the proposal would seek to save money by both limiting who may be eligible as well as changing the program standards. Pretty unusual to have such a proposal, as I said, appear in the 30-day amendments, and it's drawing very, very significant concern and advocacy from the communities that are impacted by that program. Once again, this is really the initial opening negotiating salvo from the governor. What will happen next is early in March to mid-March, each of the two houses of the legislature, the Assembly and the Senate, will issue what they call one house bills. Those are bills that are not intended to become law, but are intended to stake out a negotiating position on behalf of each of those houses. Typically, those involve either accepting or rejecting governor's proposals and then advancing proposals that might be relevant to one or more of the houses. Those negotiations then proceed in earnest between the two houses in the last 2 weeks of March, and typically to meet the April 1 deadline, which is set in the New York State Constitution. So, as Gabe mentioned, he and I are the co-deputy directors of the Government and Regulatory Affairs Group. We're actively monitoring across a wide area of proposals. And if there's anything that folks may need specific information on, please feel free to put something in the chat, and we'll make sure to get back to you about anything specific that may be impactful to your business. I don't know, Gabe, if you had anything to add to that.
No, I think you have really hit on the key points. 30-day amendments are typically not a place where we see really significant policy proposals, but in this instance, as far as a consumer-directed program is concerned, very much that's the case. There's some others that are in the healthcare space that we're monitoring. For instance, a call to essentially have a new solicitation for the managed care plans. This has been something that has been sought before by the executive and has not gone forward. That is also getting a lot of attention. That was not something that's new as of the 30 days, but nonetheless remains on the radar of many. But those are just the healthcare issues. There are issues, of course, that relate to this wide audience all across the state that as a group we're monitoring and as a team here. So Roger, thank you for the updates that you provided today. And it's our pledge that, as between us certainly and more broadly, we will keep this audience apprised as to what's coming down the pike. So again, thank you very much, Roger, for this time, and we'll see you back on the program soon. So let me shift then to our next speakers. I'm going to introduce two at once, essentially. So we're going to have both Joanna with us from our Westchester office. Joanna has been on the program a number of times previously, and I'm confident is familiar to you. She has an extensive higher education practice and is someone who has taken the time to educate all of you on more than one occasion. And so we're grateful to have her back. And she's going to be talking, as I alluded to in my opening comments, about essentially what it takes to become a university if you're a college, at least at the highest level, talking about this trend that we're beginning to see among some of our clients and otherwise in the broader higher education space. And then that, of course, is the high level of this issue. But as you get a little bit deeper into the texture of it, one can appreciate there are a wide array, of issues, including with respect to intellectual property. And we're very lucky to have Taria Jenkins, who is with us from the Rochester office. Taria is someone with deep experience in the IP space, having had lengthy stints at Kodak and elsewhere before coming to Bond. We're delighted that she can provide her perspective on what it is for a university essentially to think about protecting its brand in the context of such a change. So with that, let me first turn to Joanna, who is in Westchester, to open this set of topics for us. Joanna, thank you for coming back to the program. I'm looking forward to learning.
Great. Thank you, Gabe. Thanks for the introduction, and good to be back here on the Tuesday program with all of you. And as Gabe mentioned, I'll be discussing the latest developments from the New York State Education Department regarding colleges becoming universities. So next slide, please, Kathy. So as a college, as a higher education attorney, I was often asked, and still am asked, by people whose kids are going to college or what have you, what's the difference between a college and a university? Why are there two names for the same thing? And my answer was always, universities have doctoral programs and colleges do not. And then somebody would come back to me and say, well, this school in this state doesn't have doctoral programs, but they call themselves a university. So why isn't this a university, this other school that I'm looking at in New York? So there's a simple legal explanation for that. And as you can see on this slide, prior to January 26, 2022, so just over 2 years ago, the state of New York had a very rigid definition for what qualified, what an institution had to do in order to qualify as a university. And essentially, as you can see here, they have to offer, at that time, they had to offer a range of registered undergraduate and graduate curricula in the liberal arts and sciences, have 2 degrees in 2 or more professional fields, and doctoral programs in at least 3 academic fields. So this was a very high threshold in order for institutions to meet. And that's why there weren't as many universities in the state as there might have been in other states. And in fact, before this legislation passed, at the time, New York was the only state in the United States requiring doctoral programs in 3 academic fields in order for an institution to be a university. And as you can imagine, this played very hard on our colleges here in New York State, because it came down to kind of like a branding issue. A lot of people feel that being a university, it might be more appealing to a student, connote that there's possibly more to offer than a college. So there was a huge campaign to have the law change so that more institutions in the state of New York would be able to qualify as a university and change their name to reflect that is the case. So next slide, please, Kathy. 2 years ago, the law was changed, And now, in order to be qualified as a university in New York State, you have to be a higher education institution offering registered graduate and undergraduate curricula in the liberal arts and sciences, including graduate programs registered in at least 3 of the areas that are listed here on this slide: agriculture, biological sciences, business, education, engineering, etc. So the definition, they basically eliminated the doctoral programs requirement and the requirement to have 2 or more degrees in professional fields from the definition of university. So this opened the door to a lot of institutions that already met these requirements under the new definition and could become a university. Next slide, please. So what we've basically been doing over the last couple of years, and maybe you've noticed this out in your community, for instance, here in Westchester, Iona College is now Iona University, and the College of Mount St. Vincent is now the University of Mount St. Vincent. So we've been assisting our clients with the process of converting from a college to a university. And the first thing to do is we review NYSED's inventory of registered programs to see if our clients meet the threshold, which would be graduate programs in at least 3 of the discipline areas that are listed now in the regulations defining university. And so far, thankfully, with the institutions that have consulted with us, the institutions have met those programs, whether now that they no longer have to have doctoral programs in those areas, they're able to meet the threshold by just showing that they have master's programs in those areas. The next thing to be done was you've got to have your board vote on the move to file a petition to amend the institution's charter just to reflect the name change. An institution may become a university without going through a name change, but most of the institutions have the name college in their name. And then obviously the benefit of this is that you can change your name to call yourself a university and market yourself to the community, obviously, as a university. So a resolution has to be passed by your board. Then a petition is drafted and filed with a $60 filing fee to the New York State Education Department. The New York State Education Department's Office of Counsel reviews the petition, and if everything is in order, they then recommend the placement of the petition on an upcoming agenda for a Board of Regents meeting. And then it's essentially a consent agenda at that point, and the Board of Regents will approve it. And lo and behold, they'll issue an amendment to your charter, changing your name effective either as of the date of the vote, or you can have a prospective date. We've had a lot of clients who say, we want to file now, but we don't want this to become effective until January 1, 2025. So you can certainly file the petition and have it take effect at a prospective date. So that's the easy part. And then once that process is complete, we've also been advising clients on various issues that have come up as a result of transitioning from a college to a university. And one of those areas has been in the branding and marketing area, and protecting the institution's trademarks, changing the institution's trademarks, whatever's necessary for the need of the client. So I've been working with my colleague, Taria Jenkins, and we've been assisting a couple of schools in this area. And so I'm going to turn it over to her now to kind of give you the rundown on what we're doing for colleges and universities in this area when they go from being a college to a university.
Thanks so much, Joanna, and hello, everybody. As my colleague already said, as you consider, the college to university conversion, this may be a great time to assess, confirm, file, or refresh your trademark filings. This is a tremendous opportunity for your institution to basically represent itself and refresh the recollection of the public as to who you are and what it is that is unique about the experience in your institution. It is a tremendous marketing opportunity. So as you consider that, I would suggest to you to consider the following. You want to take stock of your trademark portfolio, and we'll talk a little bit more about that in a few minutes. You want to determine what's useful and relevant right now, what's going to be useful and relevant as you move forward as an institution. and you want to take the opportunity to basically communicate again or refresh your institution's unique value proposition and the unique experience there moving forward. Your organization has a brand, whether you are conscious of the brand or not, it has a brand, and that brand really is a unique experience and the promise of that educational experience that is embodied in and signaled by the trademarks and the service marks of your organization. I will spend most of my discussion today focused on those particular intellectual property assets, or I'm going to refer to them really as brand assets. Now, little side note on that, that is not generally legal language. That tends to be a little bit more on the marketing side of the world. But if you promise me that you will not tell my colleagues, we'll move forward using that brand asset language. And what do I mean when I talk about brand and brand asset? The word that I want to focus on most importantly is unique. What is it that is unique to your institution or organization that you want to promote to your potential constituents there? In terms of brand assets, there are many things that some of which are very obvious and some of which may be a little bit less obvious. When I say trademarks or service marks, and I use those again interchangeably with brand, those are the unique source identifiers of your goods and your services. Those can be words, logos, names, slogans, and other items that you have that uniquely identify your organizations. Things that might be a little bit less thought of in that world, your uniform resource locators or your domain names may also serve as trademarks or service marks. Social media handles and identifiers, organization and team nicknames, and then there are other non-traditional marks, such as your mascots. I noticed on one organization, they had on their website an amazing mark of a mascot that was moving across the website. You know, those are things that you may not normally consider as trademarks or service marks or assets, but they are unique assets and they are great ways to promote your story, your promise, and who you are. And so as you contemplate the name change, it is a good idea to review the portfolio of those items. And it's also a good idea to assess that, to say, what do we have? Are there things that we need going forward now that we're moving into this new realm? Are there things that we are no longer using that are not effective for us? It is interesting that there's a gamut of organizations. There are some who have relied on their common law use-based trademark rights for centuries or decades, and there are others that are very sort of proactive in the space of registering, watching, protecting, and enforcing their marks. We can help you wherever you are along the spectrum. So next slide. As you consider this conversion, here are some of the questions that you may want to ask. And this, of course, is not an exhaustive list. Does a name change automatically result in an update and protection of my brand assets or my trademarks and service marks? And the answer to that is generally going to be no. In general, what you file with the Board of Regents or that organization is really not going to have anything to do with your trademarks, your service marks. There's a different filing convention, a different set of protections that apply. And so we need to look at those things sort of in tandem. As we confirm rights in our organizational status as a university, what is the status of rights in our brand assets? So you may think about, when the time changes, just from a personal standpoint, we are reminded in the fall of the year, make sure that you check your fire implements, make sure that you check all of those things in your house that are important. And I'm going to say to you, as you make this change, although much more in a marketing sense, we ought to confirm what is our trademark portfolio? What are the marks that are key to us? Yes, it's important that our name is out there, and our name in most instances serves as a trademark or source identifier. But what are the other things that we have that are unique to our organization? Are there particular names and nicknames that have been known for decades that we use that are really, really a key identifier of who we are? Are there slogans that we have not thought about protecting that maybe we ought to really consider protecting? Are there logos that we use, different logos for different contexts, that we might need to consider protecting? These are all things that we can sit down and help you assess as you get ready to make that large change. What you might find as you do that review is that there are trademarks that have been added since your last assessment of your portfolio. There are marks that may not be used, and so it may be useful to plan for those marks maybe to be discontinued, but done in a way that is financially savvy and appropriate for your organization. And then you may also look at things that have been around for a very long time, but that no one sort of thought that, hey, these are unique trademarks and service marks for our institution. We ought to consider filing to protect those things. There's a common misconception that when you file for a name change, a corporate name change, or an institutional name change, or when you file for something like a domain name, that I automatically have trademark and service mark rights in those assets. And in most cases, there's a little bit more that can be done to protect your brand. Next slide. So let me talk a little bit about the benefits of a U.S. federal registration. As you assess your portfolio, this is probably one of the key areas that we would focus on. It is also beneficial to have state trademark registrations as well. And in some instances, we absolutely recommend that there is an overlap, that you have state registrations, which have a little bit more limited benefit, but the federal registration has tremendous benefits that we would strongly recommend that your institution take advantage of. And I'm not going to spend a whole lot of time on these, but I do want to just bring them to your attention. The nationwide rights is something that is significantly important, especially for institutions that are attracting people from all over the U.S. as well as international students. There's nationwide constructive notice of your trademark rights in a particular mark, and that applies whether a party reviews the U.S. registry or not. There's nationwide priority as of the dates listed in the registration, but also more importantly, many institutions have been around for quite a long time. And so we can indicate use dates that go back to the origin of your institution. You know, in some cases, those use rights going back to the 1800s carries a lot of clout. There are legal presumptions that you have. And those legal presumptions based on a registration give us certain advantages in enforcing your trademark rights. Those advantages are things which is particularly difficult for the opposing party to disprove. And so again, very, very useful to have a trademark registration, the right to bring your case in federal court, to use the registration symbol, and also just as a matter of practical activity, it really, when you write to someone and you explain to them that you have a federal registration for your mark or your marks, a lot of times it will really discourage an infringer from misusing your trademark. Next slide. So I would suggest that we take a holistic approach if you are considering a name change, and that you take a look at your portfolio, your brand assets. even your marketing assets, which may be items such as taglines that you may not consider registering because they won't have a long enough lifespan. But let's look at those things and just determine what needs to happen, where it needs to fit in your sort of arsenal of brand and marketing assets. We would love to help you with that. You may also want to review certain things in parallel with that portfolio review, such as your IP and your use policies. We are finding many instances where those may also need to either be implemented or refreshed, as there are instances of innocent infringement by third-party users that could be constituents of your institution, or there may be outright infringement where we need to enforce or take action. We would love to assist you, and it's been a great opportunity to speak with you.
Thank you so much, Taria, Joanna. What an interesting presentation with all kinds of implications for our institutions of higher education that are tuning in. And as we see in the chat, there's some questions about the broader implications. So, Taria, if you have a chance to tackle any of those now that you've concluded your remarks, by all means, please do. And of course, Joanna and Taria, please come on back to the program as you have updates in this space. We look forward to learning more. And let me now take the opportunity to introduce our final speaker for the day. That's Jensen, who has been on our program numerous times previously, and we're really delighted, Jen, that you've taken the time to come on back. And this is a presentation that really is 2-in-1. What we recognize is that there is a lot to tell you with regard to the New York State activities around liquor licensure. And Jen, as a big part of her practice, focuses on hospitality. There's probably no one better suited in the firm to catch all of you up. So Jen, the floor is yours. Thank you so much in advance for taking this time.
Great. Yeah, thank you for having me back on the webinar. Happy to be here. And it's like, as Gabe mentioned, I do a lot of hospitality work. I do general corporate work. I do real estate work. I do transactional work. But I do a lot of liquor licensing work. And a lot of times that liquor licensing work sort of plays into the transactional and other work I do. So I do like to give our clients updates on the Liquor Authority from time to time. I know some of you might not be in the alcohol-related industry, so I'll try to keep it relatively brief. But I have put out some blogs recently about some liquor licensing updates. So I wanted to give everybody who's joining today some insights into those. So first thing I'll stress, and if you take away nothing else from what I'm saying, is that there are a lot of backlogs at the Liquor Authority. There's great folks there, and they're working really hard, and I think they're really short-staffed. They've had a lot of changes to their systems. They've had a lot of turnover, and the backlogs, they're lengthy. I've been doing this kind of work for 20 years now. And I'd have to say, quite frankly, this is probably the longest backlogs I'm seeing. We're hoping that the things might turn around. But I did want to put out for anybody joining today, if you do anything with alcohol, you have any licenses, permits from the New York State Liquor Authority, plan on extra time for that. So one thing that the Liquor Authority has done to help alleviate that has to do with their temporary retail permits. Anybody who's joining us today who's in this space is probably familiar with these. Temporary retail permits are something that almost all of my clients apply for now when they're applying for liquor licenses. Helps them to get up and running quicker. So those permits get issued by the Liquor Authority much more quickly than the permanent license, than the license you are applying for. And they allow you to start selling alcohol while the Liquor Authority finishes its review of your full application submission. So unfortunately, due to these backlogs, my business clients are finding it's taking them much longer to get those permits issued than it used to. Back in the day, I could get those in 2 weeks. Now it's taking 6 to 8 weeks and sometimes more. That can be problematic when we've got a closing transaction, you're closing in a business, something to keep in mind. Now that temporary retail permit is issued for a 90-day period, and it can be renewed for successive 30-day periods. So another thing we've seen over the last year or so, but it continues to grow, is how long my clients are having to renew those temporary retail permits for. You're going to keep renewing those until the liquor authority reviews your full application package. And I'm finding that is now taking 6 to 12 months generally. So that's a lot of renewals, right? When you're doing it every 30 days. So one thing the liquor authority is now allowing is businesses are now allowed to renew, basically submit 3 renewals at once. So instead of renewing your permit for the 30 days, as we've always done, now you can renew it for 90 days. It's going to decrease the administrative burden on the business. It's also going to decrease the burden on the liquor authority that they're not processing one of these every month. So certainly something I'm using with my clients, something I wanted to make everybody aware of, that this is now a possibility. Couple of things I'm telling my clients to just keep in mind when they're doing this. Those fees are not refundable. So I'm telling clients, once we hit the 6-month mark or the 9-month mark, we might want to go back to start renewing in 30-day periods again, so you're not wasting the money if your application gets processed. Liquor Authority put out in their advisory that they will accept renewal applications up to 15 days after your current permit expires. So that is something to be aware of and certainly very beneficial. While operating under temporary retail permit, this takes some of my clients by surprise. Unless they have a full license somewhere else, they're going to have to pay their alcohol distributors by cash or check. They can't act on credit with their alcohol distributors while they're operating under this permit. And it can be canceled at any time. So that's something I want to make my clients aware of. I always let them know, just because you've got your temporary retail permit, it's not a guarantee that you will get your license. And it's not a guarantee that it will continue if they realize that there is a problem with the business or your application package, et cetera. So that's a recent thing I wanted to make folks aware of. And as Gabe mentioned, speaking on the second topic that I was going to bring up today, some additional insights into when you're applying for a liquor license, who and what needs to be disclosed in that application. So this is something that the Liquor Authority has now memorialized into a formal advisory, which is wonderful. This is something that over my 20 years of doing this, a lot of times we would work through with the authority on a case-by-case basis, and then sometimes things were in unwritten policies, et cetera. So they have really formalized this now, which is very helpful for my clients. So a lot of times when I start working with my clients, we start talking about corporate structure. That's where we start, because a lot of folks nowadays who are seeking liquor licenses, they have a more complicated corporate structure than businesses probably did back in the 1930s when a lot of these laws were passed. Parent entities, you've got subsidiaries, you've got brother sister entities, you've got maybe a large number of owners, maybe you've got a general partnership and a limited partnership at the top of your ownership structure. Can be somewhat complicated. And it's also more common nowadays for there to be more than one entity that's involved in the operation of business. I work with a lot of hotels, and a lot of those now are owned, the hotel is owned by one entity and it's managed by another. And that might be an affiliated entity, or it might be an independent third-party management company. So when I start working with clients, that's a lot of what I talk about. Sometimes I'm doing the transaction for them, and that's just a part of what we're working through. But sometimes I have clients come to me that they've purchased a business, now they're ready to apply for a liquor license. And we start by talking about what entities need to be on the license. Those are the entities that need to be listed as an applicant in your application package, and what individuals need to be disclosed to the liquor authority. That's always a big discussion as well. So if you've got more than one entity that's involved in operating your business, here are the things that we always start by going through. Which entity owns the real property in the building? Sometimes it's 2 different entities. Sometimes you've got a ground lease and a different entity owns the building. But what entity owns that real property? What entity is responsible for the general oversight of the business? And what entity is responsible for oversight of food and alcohol sales? So if you've got a restaurant, it's probably the same entity. If you've got something like a college and university, they might be separate, right? Might have a different vendor who's doing just food and alcohol. I work with different events, venues, things like that, hotels. might have different entities running the general non-food and beverage operations versus food and beverage. So that's something we're going to want to talk through. Another thing that the Liquor Authority is definitely going to look at is who is the employer of the folks working there. Food and beverage and non-food and beverage, which entity is employing those folks? And an absolutely key consideration is the flow of funds. Who is keeping the profits? Who's keeping the profits from food and alcohol, but who's keeping the other kinds of profits, and what percentages are being shared? Are revenues flowing into one entity and then it's paying simply a fee to another? Is there fee sharing? Is there revenue? Those are all things that we're going to need to discuss and work through to figure out which of these entities need to be a part of beyond the liquor license. So once we've done that, the next step is to figure out how each of those entities are owned. For years, I've encouraged clients to work with me to sit down and make an org chart to show a diagram showing all these entities and how they're related and who owns them. And now the Liquor Authority has formalized that requirement in their advisory that you have to submit this when you've got this when you've got holding companies in this structure. So I sit down with clients, we go through it, and we're going to draw this ownership chart all the way up to the top until you get up, for lack of a better term, up to the individual owners. Once we've done that, then we sit down and we figure, okay, we've got a lot of names at the top of this chart. Some of them are owners, some of them are officers or directors of different entities in the chart. Which of those individual people do we need to tell the liquor license about? And obviously that's a big concern, right? Because the Liquor Authority is going to consider a lot of these folks to be principals. That's the word they use. Principals are the folks, the individuals that have to provide personal information to the Liquor Authority in connection with the application. They're going to need to be electronically fingerprinted. They're going to need to give copies of their identification to the Liquor Authority. And they're going to be listed in the Liquor Authority's public database as a principal of that liquor license. So obviously a big concern to a lot of businesses as to which of these folks have to be disclosed. I won't get into, we won't go through everything. I know people, might not be key of importance to everybody, but just in general, if you're a corporation, you're going to need to disclose your president, your treasurer, and your chief executive officer. And one thing I'm stressed to clients is that the Liquor Authority's guidance says you have to disclose any officer that has a role that is similar to those if you're using a different title. So, I might have a client that says, well, we don't have a president, we don't have a chief executive officer, we have a managing director, we have an executive director. So if you have that in lieu of a president or a chief executive officer, that's still somebody's going to have to be disclosed as having an equivalent title. And you're going to also have to disclose anybody who owns 10% or more of the corporation, either directly as a shareholder or indirectly through his or her ownership of another entity that's a shareholder in the corporation. So that's where we pull out that org chart and we start doing the math, right? So if you own 50% of the parent of this entity, which owns 50%, we do the math to figure out each person, how much of the applicant, the entity that's applying for the liquor license, how much they own. And those are the folks we have to disclose. If you're an LLC, you're going to have to disclose the managing member. And again, anybody who owns 10% or more of that LLC, either directly as a member or indirectly as an owner of a member of that LLC. Not-for-profits, for any of our not-for-profit clients, this has been a very useful update. Because not-for-profits are going to have to disclose the president or equivalent title, treasurer, secretary, and chief executive officer or equivalent title for any of those. If the not-for-profit's applying for a club license, you also have to appoint what's called an alcoholic beverage control officer, and they need to be a principal. This is very important to a lot of our not-for-profit clients where we would work through with the Liquor Authority. Okay, well, we've got 30 board of trustee members. They have nothing to do with the day-to-day service of alcohol. Why do we have to, list them as principals, et cetera? So this has been, I'm really happy that the Liquor Authority has formalized this in an advisory. Something else I'll just point out to folks who might be interested in getting into the space. Any lender that's going to be providing directly or indirectly by gift or loan 10% or more of the funds that are being invested into the business, they're going to have to submit a personal questionnaire. Might not necessarily have to be a principal, but they're going to have to submit a personal questionnaire. This doesn't mean you have to get, if the funds are coming from KeyBank, you don't need the president of KeyBank to submit a personal questionnaire. But if the funds are coming from family member, your next door neighbor, a privately owned venture capital, those are conversations we should be having because the personal questionnaires might be required. And a couple things to keep in mind. One of the reasons it's so important for a lot of my clients to figure out who has to be the principals are because there are folks who cannot be principals under a liquor license. Under age 21, not a US citizen or permanent resident, having certain prior criminal convictions, not all criminal convictions, but certain ones. We'd want to talk through that. They were a principal or a licensee of a business that had a liquor license that was previously revoked or canceled. And for some kind of licenses, police officers. So something to discuss up front and figure out. And also something that comes up a lot is what's called tied house issues. If you are applying for what is called a retail liquor license, it's like a restaurant, a bar, you can't have principals who hold or are principals of an entity that holds a manufacturing or wholesale license, like a brewery, a cidery, a distillery. And the reverse is also true. So we have to really sit down with clients and figure out, okay, well, you want to bring in an investor, you want to apply for a new license, who's going to be the principals, and are we going to have this issue? And something to just, if you do end up having to be a principal of a liquor license, you're going to have to give your social security number to the liquor authority. You're going to have to give your spouse's social security number to the liquor authority. You are going to be listed in that database that I mentioned. That can be a real concern for folks because if there is a lawsuit, for example, what's called a Dram Shop Act suit where somebody's been allegedly overserved and causes an accident, your name is going to come up in connection with that application. And if you have other businesses that have liquor licenses, a disciplinary charge against one can have some impacts on the other. So just wanted to give folks a quick update on that. And that's it for me.
Jen, thank you. Everything that you've shared is so textured, and it makes it very clear that if you're in this space, it would be wise, although it's of course up to all of you listening, to perhaps get a hand to navigate it all. And people like Jen or the attorney with whom you work at Bond are well suited to do that. And we're at time for today's presentation, but I wanted to say a few things. First, in a week, you'll be back with us, we hope. And at that point, Kristen Smith will be your host to round out our February programming. I'll be back with you early in March. And in the interim, if you have any questions, concerns, guidance for us, by all means, reach out. You have the emails of the various presenters there. And we thank you very much for your loyalty to the program. We look forward to continuing to be with you every Tuesday. And in the interim, please have a terrific balance of the week.